Hello and welcome to Nothing But the Truth. At the end of a week of distressing and major revelations, how damaged is the reputation of the Indian judiciary, and has the time come for us to change the way we choose our judges? Those are the two key issues that I shall raise today with a man they call the foremost constitutional lawyer in India, Fali Nariman. Mr. Nariman, let me start with a simple, blunt question. Taken together, have Justice Katju's revelations, confirmation that Dr. Manmohan Singh and Mr. Bharwaj tried to put pressure on the collegium to promote an allegedly corrupt judge, and the belief that Justice Lahoti may have succumbed to such pressure, damaged and dented the image of the judiciary?
Oh yes, definitely, it has. And that's my great regret, that a judge of his standing, and he's a judge who did a lot of good work. He was Chief Justice of Madras, then he came to Chief Justice of Delhi, and then the Supreme Court, and so on. And the impression that was given by this revelation, and it's impressions that count in the public mind, is that this sort of thing occurs all the time. I can understand if there is a stray incident of 2005, which was the incident he mentioned, and there was some pressure brought or not brought, and that's a matter of controversy. But he should have, I wish he had said also, that this is one impression that I have. I don't speak of the entire term of this collegium and condemn this entire performance of theirs on this basis.
So Justice Katju has actually badly damaged the image and impression of the judiciary.
I regret to say so, yes.
Let's come specifically to Chief Justice Lahoti.
Yes.
After the Supreme Court collegium had decided that they would not promote Justice Ashok Kumar at the end of his tenure as an additional judge, was Chief Justice Lahoti right or wrong to entertain a plea from the government and give a one-year extension as additional judge to the same man?
No, he wasn't. And particularly after Justice Rumapal and Santosh Hegde have both confirmed that what Katju said actually happened.
In fact, Justice Rumapal has gone even further. Speaking to the Hindustan Times, as a member of the collegium, she says the decision to extend Ashok Kumar was not one taken after referring back to the collegium. Now I put it to you, was Chief Justice Lahoti right to act unilaterally, or did he once again err?
I think he may have, I mean, this is what my hunch is. One should ask him, of course, that he probably thought that the collegium would not agree with him, and therefore, like the lady from Kent, who would not go but she went, and he went along. I mean, that seems to be what happened.
But there's a corollary to what you're saying. He knew or felt that if he consulted the collegium, they'd say no, so to avoid them saying no, he chose not to consult them.
Yes, because the view that is being taken is that so far as the collegium is concerned, it requires to be consulted when a judge is appointed. And thereafter, whether there should be an extension or not is a grey area. It should be left to the Chief Justice. So that's now been decided that it's not. It should go to the collegium.
So Justice Lahoti exploited a certain grey area to ensure that the decision was the one he wanted, rather than overturned by the collegium.
Yes, that does appear to be so. But you must also add for the viewers that this was in the year of grace 2005.
Which is unfortunately only 9 years ago. It's not that far away.
Yeah, but still it's for 9 years.
Now,
and in those 9 years, there are a whole host of judges who have been appointed, who have been extended, etc., etc., etc.
And we don't know whether in their cases similar problems have arisen or not. That doubt has arisen in people's minds.
That is the problem. That is exactly. And that is where judges should have been. I wish all the judges who spoke on this issue had also mentioned whether, according to them, after this incident happened, the same sort of thing continued with pressures from the government or from any other source.
You're absolutely right to point it out. This might not be a one-off. It might be, in fact, the tip of an iceberg. There may be a much bigger, deeper, wider problem. We just don't know. And that doubt is damaging.
Most damaging.
But I want to come back to the Justice Lahoti incident for a moment's time. Justice Rumapal, who was a member of that collegium, has also said something else to the Hindustan Times. She says she wrote a letter of complaint to Chief Justice Lahoti, and he never replied. Now, was his refusal to reply simply a discourtesy, or do you think it was something more high-handedness, perhaps even irresponsibility?
Only he can answer that. But from what you say and from the facts that emerge, and I mean, reading what Justice Rumapal said, and incidentally, she was one of the most distinguished judges. My wife always says that she should have been made Chief Justice. She was unfortunately By a short head, someone else became Chief Justice. Yeah.
So if Justice Ruba Pal never got a reply to a letter of complaint, this is more than just discourtesy, this is irresponsibility on Chief Justice Lahoti's part.
I don't know about irresponsibility.
But high-handedness?
I don't know. Just neglect, I suppose. I would rather give him, give him the,
You're giving him
the benefit of it.
Let me
because after all this distance of time, we can't be so dogmatic about it.
Let me sum up on Chief Justice Lahoti and ask you this. As you view his whole behavior on this specific issue, how grievously has he erred as Chief Justice?
Well, from this disclosure, he has erred. Definitely has erred. How grievously, I can't say. But I must tell you also that he made a good judge. And he makes a very good arbitrator as well. I mean, let's
but good judges, as you're saying, can err and make wrong decisions in their administrative capacity.
Correct. But even if they are wrong decisions, it shouldn't be under pressure. Or seemingly under pressure. That is the problem.
That he acted.
You see, we all make wrong decisions from time to time, which ultimately prove to be not correct or something. That's maybe innocent, may not be innocent, etc. But if it is done or appears to be done under pressure, and that was Katju's point, if it appears to be done under pressure, then that's where the nub lies.
Unfortunately, Chief Justice Lahoti is not the only person who...
Why haven't you asked him?
Well, he's not willing to give interviews. That's the unfortunate thing. People have approached him and he said no. He simply issued a verbal statement, but that's it. But let me come back.
Because that's unfortunate.
Very unfortunate.
He should clear himself. He may have a very good excuse, very good thing.
Silence.
And silence here in this case is certainly not an option.
Unfortunately, Chief Justice Lahoti is not the only Chief Justice about whom it's suspected that he acted under pressure. His successor, Justice Sabharwal, according to Justice Katju, extended Ashok Kumar by another year. Yeah. And his successor, Chief Justice Balakrishnan, made the same Ashok Kumar a permanent judge. And once again...
Why not ask Balakrishnan?
Well, he too refuses to talk, and so too Sabharwal. None of these judges are willing to be questioned by the press. And that is another problem, isn't it? But just to come back, you have 3 Chief Justices, it seems, who have either acted under pressure from the government, or they've acted in defiance of better information which they had at hand. Isn't that a sad situation?
Yes, possibly. Therefore, Katju has achieved what he wanted to achieve, which I think is perhaps correct. That the new angle will be that we must have something other than a collegium.
Absolutely. And I'll come to that in a moment's time. No, but as perhaps one of this country's foremost constitutional lawyers, are you distressed that 3 senior Chief Justices, it is now said, or maybe it's an accusation against them, either acted under pressure from the government which they should have resisted, or they acted in defiance of better information which they had?
You see, let me tell you this, Karan, that I personally believe that when this system came about, it was meant to ensure the independence of the judiciary, and to a large extent it has.
But not in this instance.
But transparency has not been their strong point, which is most unfortunate. If there had been a regular, systemized, institutionalized basis for this committee or collegium to function, there would have been no problem. But unfortunately they thought that this doesn't require anybody's minutes or any such thing. You just fire off, appoint somebody, don't appoint somebody. I'm not saying that they don't do it carefully. They possibly do it carefully. But in order to protect themselves, it's very essential that they should have minuted things that happen. What X said or Y said or Z said.
In fact, in this particular case, 3 Chief Justices, Lahoti, Sabharwal and Balakrishnan, have benefited from the lack of transparency, from the opaque nature, and got away with actions that now seem to the rest of us as if they were both wrong, and actions taken under government pressure.
Yes. Now, but after 2005 was the same thing. Current is something I would like to know, and nobody tells us.
And that is the big problem. That's the big question mark hanging like a sword of Damocles over the judiciary.
And over this system.
Over this system. Yeah. Before I come to how we change the system, let me come briefly to how you view the role of Dr. Manmohan Singh. Do you believe that as Prime Minister, he too is guilty of breaching important constitutional principles such as the independence of the judiciary when he sought to put pressure on the collegium to A, promote a allegedly corrupt judge, and B, to do so under pressure from one of his political allies, presumably the DMK? Is he also guilty of breaching constitutional
If he did that, but I don't think that's established. The letter that seems to have been broadcast of the PMO didn't say do this or do that, but try to ensure that such and such a thing happens. That's all.
In other words, he was giving them the option to say no.
Yeah, you're right.
And Lahoti didn't say no.
Perhaps not, yes.
Which means...
He was not pressure. He didn't phone. There's no indication that the Prime Minister Manmohan Singh phoned the Chief Justice. It has happened in the past, according to legend.
But not here.
But not here.
You're saying something very important. You're saying to me, if I understand you correctly, that Dr. Manmohan Singh's alleged lapse is nowhere near as grievous as Chief Justice Lahoti's lapse.
Well, if you put it that way, perhaps yes. Yes, I agree.
And the bottom line is this. Dr. Manmohan Singh didn't actually say, do this. He simply gave them the option of thinking about it. Chief Justice Lahoti could have said no. Chief Justice Lahoti...
And there would have been an end to that.
But Chief Justice Lahoti, knowing he could have said no, and knowing that would have ended the matter, actually chose to say yes.
I wish Chief Justice Lahoti was here and we could have asked him.
But what we are concluding is that Chief Justice Lahoti, in saying yes, buckled under pressure when he could have easily stood up to it.
Well, you are saying buckled under pressure. I don't know. He may have another excuse. I don't know. Or explanation.
But till we hear his excuse, that question mark remains.
Yes, I think it's essential that some people in public life have to say something at some point of time. You have to say it. It doesn't matter what.
All right, let's at this point broaden our conversation. Unfortunately, Justice Katju's revelations are not the first time we've been informed that inappropriate people have become judges or good people have been left out. That happened.
That's more important.
Absolutely,
that's
good people being left out.
I've said that in my book also.
Now, in fact, good people being left out is what happened when Justice A.P. Shah, the former Chief Justice of the Delhi High Court, didn't become a Supreme Court judge.
And I said so.
And the present serving Chief Justice of Gujarat, Bhaskar Bhattacharya, has publicly complained that he's been overlooked.
And I've said so.
And then there's the Dina Karan case where perhaps the wrong man was about to be promoted but didn't get promoted.
I was instrumental.
And there are multiple insinuations and allegations about people promoted either in the Madras bench or the Punjab bench. Does all of this collectively suggest that the collegium system isn't working properly?
Oh, absolutely. I mean, I have no doubt it's not working properly at all. My only regret at this outburst of Justice Katju at this point of time is not that. Not that it may not be true. It possibly is true and has been now established. But the problem is that you have to, when people in high office or who have been in high office speak, they have to make it clear they are only talking of a particular incident and not of a trend.
But here, unfortunately, it seems as if it's a trend because there are so many instances, which I put to you a moment ago, of good people being left out or bad people being included. And it goes back.
That is certain. Yes,
and it's certain.
That is certain because there is, the reason is this, that there is no institutional system. There is no office in the first place. There is no office of the collegium where the data is collected, where we know whether you are better qualified or I am better
ad hoc,
qualified.
And that's the problem.
Yes.
Let me put to you...
A good chap, not a good chap. Like
let me put to you 2 or 3 criticisms made of the collegial system to see if you agree. The first is that the collegial system leaves very little room, and sometimes none at all, for the executive to play a role in choosing judges. I ask you this, in a democracy, is it fit and proper that a duly elected government should have no role at all in deciding who becomes judges?
Not at all. Not at all. But I believe that the dominant role in our situation, I'm now speaking of India, at our time, can only be that if that the executive must have a role in some form or the other, either in the form of a broad-based judicial commission, but the preponderance must always be with the judges, because otherwise you totally lose independence. And that was intended to be secured by having this system of collegium.
Which leads me to the second criticism made of the collegial system, that in fact it is opaque. There are no set criteria for choosing who will and who won't become a judge. There is no real check on the decision that the collegium takes, and the collegium has no mechanism for investigating or researching the background of the people it's considering.
And if you put in an RTI, they reject it. They say that if you apply under the Right to Information Act, this information is rejected. And this is a matter which for the last 5 years, I think, is pending before the Supreme Court.
In fact, people often say that the collegium system is a bit of a cabal. That is the exact word used by Justice A.P. Shah.
Yeah.
He says that often vendettas and rivalries and jealousies determine who is promoted and who is not promoted.
Yes, I've recited instances in my book. Yeah, correct, you're right. Absolutely correct.
So the bottom line is, just because judges are doing the choosing, there's no guarantee good people will be chosen or bad people won't be chosen.
You see, the problem is that we assume that judges who decide cases and decide cases reasonably well are not the proper persons to decide who should decide cases.
In other words, the wrong people are deciding.
Sometimes the wrong people may well be deciding, and that has happened. Because human nature is human nature. Judges don't fall down from heaven. So they are all part of us.
So before I take a break, I want to ask you one quick question as a conclusion to this part of the interview. Do we then need to change the way judges are chosen, and do we need a National Judicial Commission for this purpose?
Yes. Yes, but with a safeguard.
But Mr. Nariman, let's come to the National Judicial Commission the country needs. First of all, who should be its members?
Well, there are precedents where, in England for instance, where they are not necessarily judges. But in our situation, I'm afraid we can't have that. We have to have, first, judges, and that too sitting judges, because we can't have retired judges in the commission. There must be judges of a certain responsibility who are functioning. Therefore, that's number one. How many is a question on which there may be a debate, whether there should be 3 or 5 or 7, etc.
Let me ask you this. Should judges dominate the commission? Should it be 50-50, or should they be the same as everyone else?
No, they should dominate the commission. That's my view. They must. Otherwise, we will totally lose independence. And I am very firmly of that view. Any other system would gravely damage the judiciary, much greater damage than what has been caused by the revelations today.
Is there room on a commission that appoints judges for civil society, for what are called eminent persons?
Oh, absolutely, absolutely. All those people will come into various slots, under slots. You can put them in slots. Call him eminent, call him not.
But how
your eminent man is not my eminent man, like that.
The problem is,
who appoints the eminent man?
The problem is, when an eminent man is appointed, his critics say this is just a government representative under another name. How do you ensure eminent men are neutral and objective and not masquerading for some politician or the other?
Quite right, you can't ensure. The problem, that is why. Now, since the judiciary is functioning, and we are talking of appointment of judges in the higher judiciary, and there are 640 of them, roughly speaking, in the whole of India. The high courts are very important as well. And therefore, I'm firmly of the view that the preponderance, whether you say preponderance by 1 or by 2, whatever it is, must be with regard to the judges who are sitting, especially the Chief Justice of India. I do respect the Chief Justice of India, notwithstanding all that has happened here, or that some pressure was exercised or not exercised.
I take your point. Let's come to some other critical aspects of the National Judicial Commission. First of all, should it be a permanent body, or should it be an ad hoc body that only operates when there's need for it?
No, it has to be a permanent body, but with members for the time being. Suppose you have 4 judges of the Supreme Court. Now, if the 4th judge is retired at 65, because that's our scheme of things, there has to be the other 4th has to come in. So, in that sense, it is a slightly different body.
But when serving sitting judges are on the National Judicial Commission, are they there on deputation, or are they doing this in addition to being
In addition, they are not in deputation at all. In addition.
So they do 2 jobs together?
They have to do 2 jobs together. And that's the problem. Now, there are 2 ways of doing it. You may say, and I agree, that that's a terrific burden on them, because I must tell you that the burden on the judiciary, particularly the Supreme Court,
is huge.
On Monday, is huge.
But then how do they do 2 jobs?
Well, you have to find the time to do it. There's no other way.
It's a sacrifice a sitting judge has to make when he's appointed, when he's appointed to the commission.
Of course, when he's appointed as a member of the commission.
One other thing, should this commission simply be a recommendatory commission, or should it be the appointing authority?
No, virtually the appointing authority. Its recommendation must be binding.
It has to be binding?
It has to be binding.
So there is no room for the executive to overturn?
No, because that's the whole point. That is what the 1981 decision of the Supreme Court unfortunately said so, in a majority judgment of 4-3, after which all these various props have had to
So
come
let me sum up what we've achieved so far, because it's important that the audience should get clarity. You're saying 3-4 very important things. Number one, the commission should be dominated by the judiciary. Number two, the members of the judiciary must be sitting judges, not retired judges.
No.
They will have to do 2 jobs, but they have to find the time to do them.
Yes, they can they can sit for 4 days instead of 5 days a week.
Number 3, that this is in fact a appointing authority. Its recommendations cannot be overturned by the executive.
And may I just add?
And you're also saying that this is a full-time commission. It is not one that simply comes into being when needed.
And may I add that this job of theirs is as important, if not more important, than the cases they dispose of. They can leave the disposal of cases between A and B in the Supreme Court, not any earth-shaking cases, but A and B that come up, and yours is the General Court of Appeal. They can leave that to the others. There are now about 30-odd judges, and concentrate their attention to appointing judges, because that is where the basic foundation of the Supreme Court is to be laid.
In other words, for the sitting judges who are both Supreme Court judges and also on the commission, for them the commission should have greater priority.
Greater priority. And I'll give you an instance. For instance, when I became a member of parliament, I thought that that should have greater priority than my attending court. So I gave up some work in court and attended whatever I thought was my contribution to Parliament. So they have to do that, I'm afraid.
A couple of quick questions of detail. Should this commission have established and well-known criteria by which it considers or rejects people?
Oh, absolutely, absolutely. And that's for it to decide. We can't now tell them what is the criteria.
So it will decide its own criteria?
Yes, it has to first decide its criteria.
Should it have its own mechanism for investigating the background and track record of people it considers, or can it rely on government agencies?
No, I don't like these government agencies. This intelligence bureau and so on and so forth may be very good for various purposes, but not for judges, I'm afraid.
Finally,
there has to be some independent way of dealing with it. That's why it has to be institutionalized. That's my point.
Finally, how transparent must this commission be in its functioning?
Well, once it lays down principles, then I think you must leave it to the members of the commission, because you must trust somebody in this world. If you don't trust them, then of course I'm afraid everything breaks down and you have no way.
So they will decide how transparent they are themselves?
Themselves, they will have to. They will have to say that this is our position, this is the position. Despite certain differences of opinion, we have now chosen Mr. X. Okay, you respect that.
One proposal made by Prashant Bhushan is that they should always put up on a website the names of people they're considering, so that outsiders can make available information. Excellent suggestion.
Yes, absolutely correct.
Should we follow the South African precedent of conducting interviews in public? Or
No, I don't think that. The American system, the South African system is certainly not.
We devise our own system.
We have to devise our own system, having regard to our own genius in inverted commas.
But you're leaving it to this very commission itself, once it's constituted with good people, to decide how transparent it will be.
Yes, because it must first consist of good people.
Finally.
And not people on whom there is some doubt or difficulty.
Finally. How can you be certain that the Supreme Court won't strike down a National Judicial Commission as ultra-vires the Constitution?
No, it cannot, because there's a new Article 124A which has been added, and a corresponding article.
But it could strike that down itself as a constitutional amendment that is against the Constitution.
Yeah, but I don't foresee this happening. It could, but I'm afraid under the present law of striking down for want of basic structure, because in the first place this structure has all been devised by the judges themselves. So there is no basic structure in the Constitution that says that there should be a collegium, or there had to be a collegium. So it was their own device.
In other words, you're saying there is no basic structure that the new constitutional amendment offends, and therefore there's no basis for striking it down. One last question, and this will have to be the end question of this interview. You know better than me that many sitting judges of the Supreme Court and many retired judges are bitterly opposed to a National Judicial Commission. As this country's foremost constitutional expert, what advice do you give them?
Well, I think they are all wrong. I'm afraid the working of this commission may have contributed to more independence than they otherwise had before, but it has unfortunately weakened the whole system of transparency, because they have been non-transparent.
You're talking of the collegium. You're talking about the collegium. So you're saying to advise to judges sitting or retired who are opposed to the National Judicial Commission is you're wrong, and don't make the mistake of challenging it in court.
Please.
Please, to be polite. Mr. Nariman, a pleasure talking to you. Thank you very much, sir. That's wonderful.